Hi guys, my name is Kang. Today I will talk the topic is comparative studies of the different construction standard form of contract. First is introduction. A standard type is a text that is printed and published by a reputable business organization that is accepted by both parties. The basic form specifies the terms and conditions under which the parties' agreements will be executed. These terms or conditions are considered definitive and are not subject to further negotiations or amendment, and they are normally acceptable for a wide range of common projects or works. Next. First, I will talk about the certificate of practical completion. First is Philip Red Book 1999 years. It is using clause 10.1. It taking over certificate and the certificate issued by the engineer. The contractor will notice to engineer not earlier than 14 days before the works due, and engineer will issue or reject within 28 days. Second is PWD Form 203A. It is used clause 39.4 and certificate of practical completions. The SO will issue the certificate. Contractor will carry out the remedial work within reasonable period to the satisfaction of the SO. The last one is PMM contract 2018 years. It is using clause 15.2. The certificate of practical completions is issued by the architect, and the contractor returns notice to the architect within 14 days. Next is certification of non-completions. It is using Philip Red Book 1990 years 2, and the clause with using for certification of non-completion is clause 8.7. The contractor need to pay the delay damage to the employer for this default, and the certificate issued by the engineer. The delay damage shall be the only damage due from the contractor. Next is PWD Form 203A. It is using clause 40. The government entitled to recover from the contractor liquidate and ascertain damage. SO will issue the certificate, and the SO may deduct such liquidated and ascertain damage from any money due or to become due to the contractor. Next is Pump Contract 2018. It is using clause 22, and the contractor shall pay or allow to the employer a sum calculated the rate state in the appendix. The certificate issued by the architect, and the liquidated damage by the employer shall not be taken into account by the architect. Next, I will talk about the certificate of making good defects. The Philip Red Book 19 years, it is using clause 11.1. The engineer shall issue the performance certificate to the contractor, and the engineer shall issue the performance certificate within 28 days after the lastest of the expiry date of the defect notification periods, and a copy of the performance certificate shall be issued to the employer. Besides that is PWD Form 203A. The clauses 48.4. The SO shall issue the performance certificate to the contractor. The date specified in such certificate shall be the date on which the contractor has completed the make good such defect. Next is Pump Contract 2018 years. It is using clause 15. The architect shall issue a certificate of making good defects. The date of making good defects shall be the date of receipt of the contract written notice. All of the copies shall be extended to the employer and nominated subcontractor. Next. Moreover is defect liability period. The Philip Red Book 1990 years for defect liability period is clause 11.1. Schedule of defect is specified by the engineer on before the expired date of the defect notification period for the work or section. The contractor shall complete any work that is outstanding on the date stated in a taking over certificate. Next is PWD Form 203A is using clause 48.1. Schedule of defect is specified by the SO which he shall deliver to the contractor not later than 14 days after the expiration of the defect liability period. The contractor shall make good the defect not later than 3 months after the receipt of the said schedule provided. Next is Pump Contract 2018 years is using clause 15 for defect liability period. Schedule of defect is specified by the architect which he shall deliver to the contractor not later than 14 days after the expiration of the defect liability period. The contractor shall make good the defect specified within 28 days after receipt of the schedule of defect. Next is extension of time. FIDIC Red Book 1999 years, clause 8.1. The contractor shall give notice to the engineer. Engineer also shall review the previous terminations and may increase but shall not decrease the total of extension of time. Next is PWD Form 203A, the clause 34.1. Contractor shall forthwith give written notice to the SO. Relevant information with supporting documents enabling the said officer to form an opinion as to the cause and calculation of the length of delay. Next is Pump Contract 2018 years. It is using clause 23.1. The contractor shall give written notice to the architect. Written notice shall be a condition precedent to an entitlement of extension of time and within 28 days of the end of the cause of delay. Next, I will talk about the advantage of using form of contract. It reduces procedure costs by alleviating the need for customized contract for particular tender. The second advantage is a better chance of risk distribution that is equitable among the parties concerned. And the third is repetitive use of the document. One becomes familiar with its content and hence is conscious of both its strengths and drawbacks. The fourth advantage is standard type contract build up a body of case law to which parties may refer in the event of a dispute on any subject. It is beneficial to the entire industry. The fifth advantage is contract consistency means that there is less space for deviations from the parameters of the contract. It will make it unpractical for vendors to change the term of a deal without even consulting their clients. The last one is anytime a contract is published, the same terms are used, people can easily become familiar with the terms of their industry standard contract as a result of this, and the people will trust in the contract terms increase as time goes by. Next. The last part I will talk about the disadvantage of using form of contract. First is price fixing. One of the major problems in the case of standard contract is price fixing. If a contract has specified product price stated in it, you could be at risk of price fixing. Next one is boilerplate, which is you should never sign a standard contract in the course of your business without going through it. You may be a small business owner, but your legal rights are as important as those of large corporations who scrutinize every part of the contract before signing. The third disadvantage is favoring one party, which is when someone tells you that it's standard contract, ask him whose standard contract it is. Although the word standard sounds as if a group of entities formulate the contract after discussing an agreement upon the terms and language to be used is never that way. The last advantage is language problem, which is the word shall give off a certain connotations. When a contract says you shall do something, it establishes an obligation to perform the action. It's legally binding terminology. If a contract uses the word shall regarding something you rather not be obligated to perform, you should get it changed to may. Yeah, that's all for my presentations. Thank you.